Hi, Daniel Findling with Findling Law and thedivorceguy.com. When it comes to custody, there are two types of child custody courts really deal with. The first was traditionally called physical custody, and the second deals with legal custody. What's the difference? Well, first, let's get some semantics out of the way. The term physical custody has really gone out of favor. It's not being used. Why? Well, maybe for political correctness purposes. But more importantly, the statute, 722.26a, doesn't even mention physical custody. So what was physical custody, or what is physical custody? Physical custody describes with which parent does the child spend the majority of parenting time. So if one parent has, let's say, 51% of the parenting time, the other parent has 49% of the parenting time, well, then that parent would have been called the physical custodian. It's gone. We now simply describe that arrangement as parenting time. Sometimes we use words like the primary custodial parent, which really describes the same thing, with which parent does the child spend the majority of parenting time. And that's important because it does impact the amount of child support that's being paid. That is the number of overnights each parent spends with the child. Now, what does the statute provide? The statute provides, as mentioned earlier, about legal custody. Under 722.26a, parties must be informed of joint legal custody, and the majority of cases provide for joint legal custody. That is, simply put, that when it comes to major decisions, when it comes to choice of school, education, right, where the child's going to go to school and how they're going to be educated, healthcare decisions, and even the ability to move, legal custody plays a role. When I say move, I mean move with the minor child. Now, what happens when there's a dispute regarding legal custody, when two parties want something different? We see this a lot in the recent immunization cases that have come up. That is, one parent believes in anti-vaccination, and another parent wants to vaccinate the child. Now, in that situation, the parties, regardless of which parent has the majority of parenting time, have an equal say. And a court will hear that argument in what's called a Lombardo hearing and make a decision. In terms of vaccination, absent really an extraordinary circumstance, courts are going to award that the child becomes vaccinated. Now, when it comes to choice of school, maybe a parent has moved and remarried and gone from, say, a school in southeastern Michigan to another school that maybe isn't as, well, let's just say academically savvy. Now, even though that parent may have the majority of parenting time, or what traditionally was called the physical custodian, does not mean that they get to choose the school. That is a joint legal custody decision that requires both parties to agree. And if they can't agree, we have another type of Lombardo hearing. And there's a Supreme Court case called Parent versus Parent, which describes how we make that decision. Now, even though the majority of cases provide for joint legal custody, there are some instances where joint legal custody simply does not work, specifically when the parents cannot agree on anything. Although it's rare, in this blog article, we're going to talk about such a case. We welcome you to visit the website and ask a question if you have any. Of course, you're free to call us at any time at 877-YOUR-FIRM, or simply responding here on the website. I'm Daniel Findling with Findling Law and thedivorceguy.com, and thank you for visiting.